As the world is becoming more connected, international trading has increased enormously in recent years due to the acceleration of globalization. Increased globalization gives countries new opportunities to access the global market. From industry to industry, word definitions often vary, especially concerning global trade. This makes international trade language one of the most important and complex instruments. Any misunderstandings of different commercial practices in respective countries may cause conflicts resulting in costly litigation. Therefore, the ICC published the Incoterms as a common language. In this video, we will talk about the concept and development of Incoterms, the responsible organization behind it, its illustration in commercial practices, and the assessment of its effectiveness.
Incoterms is a standardized set of international trade terms published by the International Chamber of Commerce. It is an acronym of International Commercial Terms. Incoterms are for a bundle of specific rights and obligations allocated as between the seller and buyer in contracts for sale of goods. It indicates which party is responsible for the cost of transportation, transfer of risk of loss, export or custom clearance, whether goods are to be delivered, and in some cases, who arranges insurance. Incoterms is widely used in international sales by incorporating into contracts by express reference, as it provides internationally accepted definitions and rules of interpretation for most common commercial terms. It is divided into two distinct categories, which are deliveries by any mode of transport and delivery by sea or inland waterway. Incoterms is an efficient aid in the international trading contract. Its main aim is to avoid any misunderstanding that may arise between different trading practices in different countries. To keep pace with the rapid growth of international trade and globalization, Incoterms is updated every 10 years. It has been updated 8 times, which has resulted in Incoterms 2010. A Trade Terms Committee, with the assistance of the ICC national committees, developed the first 6 rules in 1923, which are FOB, FAS, FOT, FOR, 3 delivered CIF, and CNF. These were the precursor of what would later be known as the Incoterm rules. In Incoterms 2010, there are now 11 rules rather than 13 before. DAF, DES, DFQ, and DDU are replaced with DAP and DAT. The rules are split into 2 different classes relating to mode of transport used. It is more user-friendly and reflects modern trade language, which is electronic communication. The rules is capable for international and domestic trades. Changes with cargo security. Incoterms 2010 imposes an obligation on both parties to provide the other party with the information that they need in order to obtain these clearances. It clearly allocates terminal handling charges in the terms. Information on insurance cover have been moved from more generic articles. This is to take into account the amendments made to the Institute cargo clauses with regard to those rules which require a party to obtain insurance, that is, CIF and CIP. Incoterms was first conceived by the International Chamber of Commerce and brought to fruition with the first Incoterm rules in 1936. It is the only representative body that speaks to authority on behalf of enterprises from all sectors in every part of the world. 3 central functions of ICC is to provide the rules and standards that govern international business, promote open, cross-border trade and investment, free trade, help companies and states settle international disputes. Members of ICC are experts from all parts of the world. Therefore, the first initiative of ICC to facilitate international trade was to explore understanding of trade terms in the 1920s and to publish the results of their study in 1923. The studies demonstrated disparities in the interpretation of the trade terms. Incoterms 2000 is still valid. Traders just need to state which Incoterms they are using in the contract. Incoterms 2010 became effective on the 1st of January 2011. Incoterms do not have any law status. It just provides rules and guidance for international trade parties. Therefore, it is not compulsory for every trade activities to use it. In fact, there is no default Incoterms. To ensure validity of the terms, it has to be included in the contract explicitly. Sales contract can be governed by the law of country where the parties decide applicable to the contract or where the seller is situated. The scope of Incoterms does not include intangibles such as computer software.
We will be illustrating 5 out of the 11 Incoterms in this presentation. The 5 are EXW, FCA and DDP from the first category, FOB and CIF from the second category. EXW stands for X Works and sometimes referred to as X Factory. Under this term, the seller simply makes the goods available to the buyer at the seller's named place of business or factory door.
These rules can be illustrated in the example below, where the seller, located in Sydney, Australia, is going to export stainless steel equipment to the buyer in Iowa, USA. Delivery is completed at the seller's works prior to loading on the truck, not clear for export. All transport costs beyond this point are for the account of the buyer.
EXW rule places the minimum amount of risk and responsibilities on the seller. By taking delivery of the goods at the seller's works at origin, the buyer is responsible for the well-being of the merchandise as well as all transport and related costs up to the final destination.
The seller is not required to load the collecting vehicle at her works, nor is she called upon to effect export custom clearance. If the seller does load the collecting vehicle and carries out export custom clearance, it is done at the buyer's risk and expense. The FCA term is unusual in the fact that there are two identified delivery points. The first being the seller's premises when the seller loads the cargo onto the buyer's transport. The second being where the seller delivers to the buyer's first carrier or freight forwarder at their depot or similar place. The seller is not required to offload the cargo at this point. For the proper implementation of this rule, the seller and buyer have to explicitly agree on who the carrier will be. With the buyer responsible for nominating the carrier, the seller can end up turning goods over to a trucker at his factory, a freight forwarder near a port or airport, or directly to a steamship line or cargo airline. When the seller delivers to that named delivery point, all subsequent risks and responsibilities fall to the buyer. There are two examples of commercial contracts below. The offer to sell leather black shoes involves a company in Bangkok, Thailand, and a potential buyer in Madrid, Spain. In the upper right-hand corner is the initial reference to the shipping term used, FCA Seller's Facility. There are no transportation charges listed on the quotation. This is consistent with the meaning of the FCA Seller's Facility, where the seller is responsible for loading the truck as well as export customs clearance. All other transportation and related charges are for the account of the buyer in Spain, including inland freight to Bangkok Airport, air freight to Madrid, customs clearance, and local delivery at destination. The second example deals with delivery point that is other than the seller site. This invoice covers a shipment from a company in the great city of Lynn, Massachusetts, USA, to a customer in Bogota, Colombia. The circular areas show that the delivery terms are FCA Latin Cargo Incorporated in Miami, Florida, which is the carrier's facility. With regard to the price, it can be seen that the seller has included $1,200 as inland freight from Lynn, which is the seller's factory, to Miami, which is the carrier's facility. The seller pays the inland freight, but the buyer is responsible for offloading of the good at the carrier's facility and all other related charges at this point onward. DDP, or Delivery Duty Paid. DDP carries the maximum amount of risk and responsibilities for the seller. DDP compels the seller to pay for all transportation costs up to a named place of destination along with custom clearance, duties, taxes,
and VAT. The parties must agree on the name place at destination. Because DDP can be used for any mode of transport, the name place could be a port, airport, third-party warehouse, or ultimately the end user's facility. For example, we'll review an airway bill for a DDP shipment going from a supplier in Manchester, England, to a company in Springfield, Massachusetts, USA. The circle area says delivery duty paid Sturbridge Importers LLC in Springfield, Massachusetts, US. This means that the seller has to pay all costs up to the buyer's facility in Springfield, Massachusetts, including custom clearance, duties, and taxes. FOB or free on board. Delivery occurs at the origin port, cleared for export, and loaded on board the vessel. All transport or custom expenses beyond these points are for the account of the buyer. FOB has only been intended for maritime or inland waterway transport, where the seller's delivery obligation ended in the port of export once goods have been loaded on board the vessel. In this example, the seller located in Vancouver, Canada, is going to export loose grade A summer corn to a buyer in Valparaiso, Chile. The Incoterms rule in the circle area names a port of export, which is Vancouver. This means that the seller is responsible for risk of loss or damage and inland transportation costs until the goods are loaded on board the vessel. Once that happens, delivery has occurred and all responsibility shifts to the buyer. Finally, the second circle area conveys that the goods are arriving at Vancouver Port by rail and that loading is the responsibility of the seller. This statement is consistent with the definition of free on board. It also states that all charges beyond the FOB point are for the account of the buyer. CIF, or cost, insurance, and freight. The seller arranges for the goods to be delivered to the named port of destination. However, the seller's risks do not end until the moment the goods have passed the ship's rails at the named port of destination. The seller is responsible for all costs until the goods have been unloaded at the named port of destination and also provide minimum cover insurance. In this case, the named port of destination is domestic to the buyer, meaning that the named port must be a port in the buyer's country. An example in practice is illustrated as follows. This example is for a CIF export quotation going from a chemical company in Mobile, Alabama to a company based in Hanoi, Vietnam. It can be seen in the quotation that it listed the price of the goods on a CIF basis, which is the cost of the potassium nitrate plus ocean freight and minimum cover insurance. There is no inland freight shown at origin as the seller will pump the chemicals into the ship from a tank farm adjacent to the berth in Mobile. Note that CIF is one of the two Incoterm rules that obliges the seller to secure minimum cover insurance on behalf of the buyer. The other one is CIP.
The use of Incoterms is said to add effectiveness to international trade due to several reasons. First, it provides consistency and common understanding between foreign trade parties. This applies to a situation whereby the seller and buyer are located in different countries where each has different trade practices and legal systems, customs, and often language. The Incoterms rules are recognized by UNCITRAL as the global standard for the interpretation of the most common terms in foreign trade. The Incoterms rules has translation in 31 different languages. Thus, this minimizes cross-cultural misunderstandings and remove uncertainties when it comes to different interpretation by clarifying the task, cost, and risk involved in the delivery of goods from sellers to buyers. Next, it reflects contemporary commercial practice. The recent Incoterms 2010 has adapted to contemporary commercial practice in terms of classification of rules, security, and insurance. First, classification of rules. New classification of Incoterms better reflect modern commercial reality. Under Incoterms 2010, the ICC has divided the Incoterms in accordance with the means of transportation. This new classification system provides clarity. In Incoterms 2000, the ICC namely mentioned that FOB rule was often erroneously used to indicate any point of delivery, such as FOB factory, FOB plant, FOB ex-seller's works, or other inland points, thereby creating confusion, given that the FOB rule was meant to be used solely for sea and inland waterway transport. Second, security. In light of the heightened security concerns since September 11, 2001, certain new rules allocate obligations between buyer and seller with regard to obtaining security-related clearances. For instance, the new EXW rule states that the seller must provide, at the buyer's request, risk and expense, any information in his possession that is required for the security clearance of the goods. Third, electronic communication. The new Incoterms 2010 rules provide that, to the extent that it is agreed upon by the parties or that it is customary, electronic records of procedures have the same effect as paper communication. Incoterms 2010, which has been adapted to contemporary commercial practice in the three areas mentioned, enhance practicality for fast-moving international business. Lastly, it provides well-designed mechanism for delivery rules and enhance the speed of negotiation. Although sellers and buyers may be free to agree to any condition they wish, both parties are usually better off using well-established sales terms rather than inventing their own. The parties can refer to benchmark terms to ensure that they fully understand their respective obligations. These terms are also available for reference to others outside the sales contract, but indirectly involved in fulfilling it, such as forwarders, carriers, and insurers. In case of a dispute, judges and arbitrators could refer to well-established terms rather than having to determine what the parties actually intended. Incoterms offer parties an opportunity to clarify their roles by using internationally accepted contractual standards, thus reduce the possibility of delay, contractual ambiguity, and disagreements. However, Incoterms have several limitations. First, Incoterms are not law. Incoterms are merely guidelines to assist international trade. Sellers and buyers are not obliged to incorporate them in a contract. However, it can be enforced between an exporter in one country and an importer in another. When a trade term is referenced in a contract, that terms take on the force of law, and any question regarding delivery of the goods will be interpreted pursuant to the Incoterms rules. Next, not all Incoterms require seller or buyer to be insured. Out of all 11 terms, only CIF and CIP require sellers to provide insurance. However, they do not do adequate job covering insurance because they accept sellers' insurance at minimum coverage, which is sometimes inadequate for most shipments. Therefore, the parties have an obligation to common sense to arrange for adequate coverage and should do so outside these remaining Incoterms. Lastly, confusion may arise in choosing the appropriate Incoterms, which may result in inconsistency between the chosen Incoterms and the provision of a sales contract. This can be illustrated to the commercial court case of Euro-Asian Oil SA against Abelo UK Limited, which was reported in December 2016. One of the key areas considered by the court in examining the transaction was the relevance of the Incoterms quoted in the sales contract. There, the title transfer provision of the contract and the stated documentary requirements for title delivery or the period of time for payment did not conform to the relevant Incoterm. In this case, CIF was used and it became less applicable to the actual conduct of the parties as the transaction progressed. During the trial, the claimant accepted that the contract were not CIF as a matter of law.